Hello everyone, welcome back. Today I want us to consider why it's taking so long for unconstitutional laws to be nullified in the courts. Okay, so we had the Hell decision, we've got the McDonald decision, and then on top of that, now we've got the NYSERPA, the Bruin decision. And basically, the Bruin decision pretty much laid it out that, it is safe to presume that all gun control laws are unconstitutional unless the government can come back and say that, hey, there was a similar law that existed in 1791, and on that basis, it is constitutional. Okay, but unless they can prove that, right, the burden of proof is on the government to prove that there was a similar law existed in 1791. Otherwise, it is presumptively unconstitutional, and that was the word that Clarence Thomas put in the NYSERPA v. Bruin decision. Okay, there's this presumption of unconstitutionality of gun law. So the question now that we're considering today is, why is it taking so long for the courts to start, just throwing out all these anti-gun laws or all these gun restrictions? So here's the thing, that first of all, as far as the Supreme Court, it does not have any enforcement powers. Okay, so the Supreme Court depends on the lower courts to enforce their opinions, right? And my thinking is that if the Supreme Court comes in too hard, too heavy, seems to completely disrespect the lower courts and the judges on the lower courts, basically they're just going to fold their hands and basically just, refuse to do their job. Okay, so I think that is one of the things that the Supreme Court is trying to balance out, how to kind of coax these lower courts along, given that they don't have any true enforcement powers. Okay, so that's the first issue that we're running into. Okay, now the second issue, when we look at the lower courts now, what I think is happening is, on the liberal side, right, or on the Democrat-appointed judge side, those judges are trying to delay these cases as long as possible because they're simply hoping that the older conservative justices like Clarence Thomas and Alito are going to die off, and they're going to get to replace them. So they're thinking, hey, Biden's got 2 more years, maybe they can get him reelected or get another Democrat reelected, or maybe if Trump runs, people are going to just run away from Trump and vote for whatever Democrat is running, and they'll get a chance to replace Clarence Thomas and Alito. That's the line of thinking of the Democrat-appointed judges. They're going to slow this down and delay it as much as possible. But aside from that, there's also, on the conservative side or the constitutionalist side, those judges also seem to be going really, really slow. Okay, case in point is Judge Benitez in California. I mean, he's already made a decision once that AR-15s, AK-47s, it cannot be banned in California. Standard capacity, 30-round magazines cannot be banned. The handgun roster, all this has already been done. All right, it's already been decided, and yet it's still being slowed down. In many cases by constitutionalist, originalist judges. Why are they doing that? Right? So that's kind of the thing that I wanted to put out there. I wanted us to consider. Okay, so for one thing, when we're looking at these constitutionalist, originalist judges, they're not trying to give us the decisions that we want. They're trying to basically be constitutional, right? So what they're doing is they're trying to, basically play within, work within the rules, okay? And they want to make sure that they are working within the rules. By contrast, the Democrat judges are activists, okay? So they don't care about working within the rules. If they get a majority, they're not going to even put much thought into it. They're going to immediately reverse pro-gun, decisions. Okay, whereas the conservative judges, constitutionalist judges, they're not so much interested in protecting our gun rights as I see it. They're more interested in protecting the Constitution and the original intent, and they want to make sure that they're following the original intent. So on the left side here with the Democrats, they're going at a much faster speed because they're okay with just pulling decisions out of their asses, whereas the conservative judges, they're going a lot slower because they specifically don't want to pull decisions out of their asses. They want to make sure that they're doing it the right way. Okay, so that's kind of working against us, okay, in a sense, as far as the time restraint here, because there is a time restraint here. The time restraint is that if Clarence Thomas and Alito pass away, if the Democrats get to replace those judges, we're going to start seeing a lot of these pro-gun decisions starting to get overturned, okay, and reversed on us. So now the other thing that's happening, okay, is with a lot of these conservative judges, they see, they see the law as kind of like poetry, artwork. Okay, so if you notice, like a lot of the words that, for example, if you read Clarence Thomas's decision, he was very careful which words he used, and the words kind of flow. So to these judges, the words that they say, the way that they craft their decisions, they see it as artwork, okay? And in their minds, like, you can't rush artwork, because the decisions that they're handing down is not just for here and now. They basically are trying to establish their place in history, okay? So the same way, like, these judges now are looking back to, like, the decisions of, Judge John Jay and Marshall and a lot of these older, long gone judges. They want judges in the future to look back and basically say, hey, here's Clarence Thomas from whatever, 100 years ago or 200 years ago, and these are the wise words that he said, and look how perfect this decision is. And so that's what a lot of these judges are thinking of, right? They're thinking of how they're going to be seen in history. So they're not just handing down decisions the way we would like them to do it, right? For the purpose of just clarifying the meaning of the Second Amendment. They're in the process of making a sculpture of themselves, okay? And they're thinking ahead to how people down the road in the future, 100 years from now, 200 years from now, when they're reading back and they're looking at the decisions that they authored, how marvelous it's going to be, and how artistic and how beautiful and how poetically it flows, okay? So these are the things that matter to these judges. So so that's, I just want us to consider this, and to be aware of this, and understand that this is really working against us to some extent, because it's slowing things down, and they're trying to carve out their place in history. But the problem is, if they expire too quickly, they're not going to get to establish their place in history. For example, Clarence Thomas's decision, if the Democrats get control of the Supreme Court, they're going to take that beautiful decision, that beautiful order decision that he wrote, and they're going to crumble it up, and they're going to throw it in the garbage, okay? So that's one of the things that I do not think that the constitutionalist judges are considering, right? They're just considering how they're going to write these beautiful, artsy decisions. They're not considering that they got to get them done, they're not considering that they got to get them done fast, so that they'll actually have a time to stick, okay? So anyway, just wanted to throw it out there. I wanted us to consider this, and my thoughts on why things are rolling so slow for us. Thanks for watching. I'll talk to you all soon.